family mode.
Good afternoon, everybody, and welcome to the September webinar for Kevin Davis Insurance. My name is Sherry Branson, and I'm your host today. I have a very special guest joining me today, Senior Claim Representative for Travelers Insurance, Rachel Plzak. Hi, Rachel.
Hi, Sherry.
How are you?
I'm doing well, thank you. How are you?
Doing well, thank you. Thank you for joining us today.
Thanks for having me.
Yeah, it's wonderful. And Rachel, could you share with everybody joining us today what your background is with Travelers?
Certainly, I've worked for Travelers for 14 years. The first 3 years of my career here, I handled global marine claims, and then moved over to handling directors and officers claims since then.
Okay, 14 years. I'm sure it's gone by very quickly.
Indeed, it has.
That's great. And Rachel, what do you like to do for fun?
Well, this time of year, I like hiking and running outside. It's so beautiful outside. And reading.
Great, great. Yeah, and I know you're in Connecticut, correct? So you're in the part of the country that has beautiful foliage this time of year.
Exactly, yeah. Beautiful.
And it's cooling off a little bit there, which is wonderful. Yeah.
Exactly, making it a little more easier to be outside, yeah.
Yeah, for sure. Yeah, it's my favorite time of year there. It's gorgeous. Well, that's great. Well, thank you, Rachel. And Rachel, today we're going to talk about top D&O claims for community associations. And you work in that department, so you're well aware of what's going on in the claims world. And let's see, we're going to talk about the latest claims situations, et cetera. And then I wanted to start out with kind of a general overview of D&O liability for community associations and why they need it, and then talk about the definition of a claim. Basically, D&O liability protects the insured for claims brought against them alleging wrongful acts. The board members are volunteers, and it's their job to maintain, enhance, and protect the assets of the community association. D&O liability protects them when a unit owner, a renter, or a contractor is upset because they believe the board is not looking out for the best interests of the association. Now, a wrongful act, what's the definition of that? It's basically an act, error, or omission. An example would be if the board decided not to put a new roof on the association and they were the homeowners were upset about it, or somebody was upset about it, and they decide to sue, then that could end up being considered a wrongful act. And we're talking about claims, of course, today. We're going to get into depth about claims. So basically, to define a claim, there are several definitions for it. One is a written demand for monetary or non-monetary relief or damages. And Rachel, when we say non-monetary, can you talk about that a little bit? Because I know that's pretty common in the association world because a lot of these claims are very emotional.
Certainly, a non-monetary relief could be requesting documents from the board of directors, or it could be asking them to have a neighbor remove a fence or cure, a barking dog, something like that, where it's not, attorney's fees or money that they're looking for.
And I know that sometimes these non-money claims can turn into money claims, correct?
Certainly, especially if once the demand for the non-monetary demand has been made, if it is not produced and the person hires an attorney, then you're looking at attorney's fees and it becomes a monetary claim.
It turns into an expense. Okay, thank you very much.
Exactly.
And the other definitions are civil proceeding commenced by service of a complaint, criminal proceeding commenced by return of an indictment, and a formal administrative or regulatory proceeding against an insured for a wrongful act, as we just talked about wrongful acts. Now, Rachel, we're going to talk about the top 5 categories that we're seeing claims in, and then we'll also discuss other areas where claims are coming in as well. And the first one that comes to mind where we're seeing a lot of claims is breach of fiduciary duty. Could you expound upon that a little bit and define that for people?
Certainly. When anybody runs for the board, they basically take an oath that they're going to make their decisions for the best of the association. That's their fiduciary duty. They make their decisions for what is best for everybody in the association, not any one particular homeowner, and certainly not for themselves through the board. Now, under the title of breach of fiduciary duty, there are a number of different kinds of wrongful acts that can fall under that heading. Certainly asking for documents and having them not given, giving a contract to do work in the association to a relative, or failure to follow up on a homeowner's concern if they say, like, they see debris and graffiti in a certain area of the association and no one follows up on it, and that leads to something, a crime is committed, etc., then they could say, you breached your fiduciary duty, I brought this to your attention, you didn't look into it.
Mm-hmm.
So, yeah.
Mm-hmm. So it really covers a broad area, breach of fiduciary
Yes.
duty. Mm-hmm. Okay, thank you very much. Thank you for explaining that. And I did want to mention, if you'd like a copy of today's presentation, the PowerPoint slides, I can send them to you. I can email it to you. My email is sbranson@kdins.com. And I also wanted to mention that we put copies of the live recording of each webinar on our website on the homepage. The webpage is kdisonline.com, and you'll see a webinar link there. You just click on that link and you can listen to all of our webinars. And Rachel, another category, another area that we're seeing a lot of claims in is this violation of CC&Rs, which is the bylaws for the condo associations and the homeowners associations. What are you seeing there?
So when people buy into an association, there's an agreement that they're all going to live by these CC&Rs, and part of what's in them is how the board is to run things, whether it be how often they have meetings, how many people will be on the board, what percentage of the homeowners they need if they're going to pass a special assessment, and if at any time someone feels that the board has not done that, if they have not noticed the meetings properly, if they are not holding meetings regularly in accordance with the CC&Rs, then they can file a complaint for violation of CC&Rs.
Mm-hmm, absolutely. And I live in a homeowners association, and to be honest with you, I've read them, but I read them 5 years ago. So if I was tested on them today, I would not know them all. And I don't know if you've read yours, but a lot of people just don't read them and they're not familiar with them. So, I don't know if the boards, it's a good idea for boards to be up to date and stay fresh on the CC&Rs to make sure they're not violating them. And another area, which a lot of homeowners associations, of course, have landscapers, they have painters, they have lots of contracts with lots of vendors. Breach of contract, that's a really big area for claims.
Mm-hmm. Yes, we see it can come in the form of termination of a contract too early. A board of directors is unhappy with somebody's work and they decide to terminate the contract and hire somebody else. Well, that early termination, if it's not done in accordance with the contract, can be deemed a breach of that contract. Again, if the board is unhappy with the work that a contractor is doing and they decide that they do not want to pay, well then, again, there's that liability of the outstanding balance that can lead to the breach of contract complaint. And I would like to clarify that under this policy, we do provide the defense for breach of contract. However, any award of indemnity, if the outstanding balance was awarded to the plaintiff, and any attorney's fees that were brought because of this outstanding balance would not be indemnified by a D&O policy.
Oh, okay. So that's a good distinction to make sure people are clear on that. And if anybody has any questions about what she just mentioned or wants us to send you more information about this, please send an email or give us a call, and we're happy to answer the question in depth. Thank you, Rachel.
I suppose I should clarify that when I said it's not covered by a D&O policy, I mean our D&O policy. I can't speak to other people, so
sure.
Just to clarify.
Okay, by our D&O. Okay, great. Thank you. Thank you. That's our D&O. Great. And now another area that I've seen quite a bit of activity in, Rachel, is discrimination. Can you describe what would be a discrimination claim and why is this coverage important to an association?
So an example would be there's a community association swimming pool and you have a family with kids. Some of the kids know how to swim, some of the kids don't know how to swim. Some of the kids are in diapers, some of the kids aren't in diapers. And the board tries to pass some rules saying, no one in diapers can go in the pool and you need to know how to swim if you're going to use the pool. That can lead to a discrimination complaint. You can't, once somebody is in your association, they have the right to use the amenities as everybody else does. So.
Sure.
And another big one that we see is the emotional support animals or service animals that, the condo association or an association may be pet-free, and somebody comes in and says, I have epilepsy, I need to have this service dog, and the board, needs to take care of that or allow it, or it can become a discrimination complaint.
Can become an issue and a claim. And you mentioned emotional support animals. Just so, if anybody has never heard of this before, basically it's kind of a trend over the past few years where it could be anything from a chicken to a squirrel. I mean, there's lots of unusual potbelly pigs, I know, have been considered emotional. So it's not necessarily always a dog and a cat. And it's if I have a particular medical condition, my doctor writes a note and says Sherry needs to have her potbelly pig. And so that's what an emotional support animal is. It can be a very unusual animal.
And I mean, it becomes very tricky for the board because it's if you ask for too much information about the disability, that can be seen as sort of a hostile environment for that person who's asking for that reasonable accommodation. So in those cases, I think best to consult with your general counsel and make sure that you are following all of the protocol that should be followed when requests like that are made. And in the same vein as the ADA, American with Disabilities, I want to let people know that also there is some exposure for discrimination when unit owners are renting out their units. They may sort of unwittingly get themselves in a pretty dangerous spot with the liability, because if they're opening up their unit to the public by offering to rent it, say on Craigslist or what have you, they will need to be compliant with the ADA requirements, and that can lead to a discrimination complaint against the association, whether the association is aware that the unit owner is renting out the units or not.
Okay, that makes a lot of sense. And in some situations, in some of the vacation where a lot of condos are in vacation hotspots, some of the condos could be up to 70% rentals. So that's happening quite a bit. And I could see that opens up a whole can of worms.
Yes.
Absolutely. And Rachel, another area that we're seeing is, I know a lot of these associations, of course, are hiring employees and they're firing employees. They're doing this every day because they have employees on staff. So they're basically making decisions as if they're a human resources department, HR decisions, hiring and firing. So employment practices liability, that's a big area as well.
Certainly. We see claims for termination, that they, wrongful termination or wage and hour claims, but we also see sort of discrimination within the EPL arena. I had a claim where a woman applied to be a property manager, and it was going to be for 2 buildings. She was going to be the property manager for both of them. And she got a phone call from the acting property manager saying, the board wants to offer you the position, and she let him know at that time that she was pregnant. And the property manager said, let me check with the board and I'll get back to you. And he called her back and said, the board doesn't want to deal with that, so you don't have the job. That was a very costly decision.
Yes.
So,
okay. That's,
I'm a big proponent of, if you have a question about it, use your general counsel. Certainly with EPL, it's always good to have an employee handbook, have protocols in place, and document everything. So if there is an incident, no matter how small, document it so that if they ever have to make the unfortunate decision to terminate somebody, they have all of the evidence to support that decision.
Absolutely, absolutely. And as I mentioned earlier in the webinar, the board members are volunteers. They don't have a legal background. Some may be lawyers, but not necessarily community association lawyers, and they're not human resources professionals, so it really is a good idea to speak to your counsel.
And it's typically not a good idea to have a board member acting as an attorney while they're on the board.
That's a good point.
Gets into some muddy waters. That's a good thing to keep separate.
Absolutely, absolutely. Great, thank you. And I know there's some other claims, in the other areas that we've seen, Rachel. Could you explain, we've seen a few insured versus insured claims. Now, what would be an example of that?
when you have an outgoing board and you have they turn over all the documents to the incoming board, and the incoming board takes a look at all the documents and feels like, they were aware that we needed to have a new roof and they didn't get any reserves, they didn't collect any reserves. Now, we needed, to have this done immediately and we don't have the funds to do it. Or picking a contractor that was their uncle or something like that. So one board could say to another board, hey, your decisions were not made in the best interest of the entire association. You hired someone that you were related to as a favor as opposed to picking, the contractor that was, best for us. So something like that.
Okay, insured versus insured. Thank you. Thank you for explaining that. And then, the board members, they have a treasurer, they're managing the association funds. I've seen a couple of mismanagement of association fund claims. Now, have you seen those as well, and what have you seen there?
Certainly. So mismanagement of funds, it's not unusual to have funds that are earmarked for specific projects. You have a special assessment, you're going to put in new flower beds. So you collect all of this money, you put it aside specifically for flower beds. Well then, they decide to just spend it on something else. They don't have enough for snow removal, something that's common here in Connecticut, and they use the money for the flower beds and decide to use it for the snow removal. That can be a mismanagement of association funds.
Oh, okay.
So they're using money that's earmarked for something else.
Okay, great. And I did want to mention that I also have a flyer. I have a claims flyer which has claim examples on it. So if you'd like a copy of the flyer and the presentation today, please send me an email at the end to sbranson@kdins.com. I'm happy to send you a copy of our flyer, our claims flyer. And Rachel, I know this is kind of a sticky area for a lot of board members and for a lot of associations because it's uncomfortable, but there are also many legal aspects to it, which is wrongful foreclosure.
Yes. So there's two types of foreclosure. There's judicial and non-judicial. Judicial foreclosure is the court is involved every step of the way, overseeing everything and making decisions. Non-judicial foreclosure you do by following a series of statutory steps, which includes, several mailings to the person who has the outstanding debt. If there's no response to that, then there's the publishing of the foreclosure, but many steps. And it gets tricky because if any step is done incorrectly or is not done, it can invalidate that foreclosure, which can become a big mess if you have somebody who's already come in and purchased that property. Then you have a upset new buyer as well as the person who's been foreclosed upon.
Okay, because of there are so many steps and so many rules involving this, it's complicated and a lot of room for error, basically, for things to happen.
Exactly. Exactly.
Okay. That makes sense. And Rachel, I know that a lot of people, will get there's an architectural committee at many associations that approves architectural changes. If somebody wants to put a wall up or a fence or change something on their house. So architectural violations, that's kind of a big area, isn't it? Do you agree with that?
Yeah, and we see those claims in various forms. We see the person who is applying to, put up a shed in their backyard and the board denies it and they're upset and they file a complaint. They feel like the board is being arbitrary and capricious and that other people have sheds and they don't have a shed. The other side of that we see is the neighbor of the person who has made some changes, and they feel like whatever change has been allowed somehow diminishes the value of their property, and they're very upset that the association ever allowed this to happen. So we see both sides.
Both sides of that. Okay, thank you. And one thing that I noticed, we saw it a few years ago with a lot of high-rise associations or mid-rise associations where people are putting in hardwood floors. So we saw kind of an influx for a while there of noise complaints related to hardwood floors. And I know that can go in a lot of different directions. It could be a dog or it could be, different areas. But this is also an issue as well.
Yes, I mean, and certainly it typically would come in as a nuisance, and, under the CCNRs, when people buy into an association, they essentially agree that, they're not going to create a nuisance, and there's protocol within the CCNRs that the board can follow to help abate such a nuisance. But if you're the person who's got somebody upstairs, with high heels on a hardwood floor, and you're going to be pretty upset. So you reach out to the board and ask them to take care of this. The board, either does or does not do what they can. Either way, if the nuisance is not abated and that neighbor files a lawsuit, typically, even though it's a neighbor versus neighbor issue, the association will get brought in for failing to abate that nuisance, and that they're not enforcing the CCNRs, which does not allow for people to create that nuisance.
Okay. Okay, thank you for explaining that. Thank you very much. And now with all these issues, with the boards dealing with lots of issues from noise situations to contracts to hiring and firing, questions are popping up all the time in their minds. And as I mentioned, they are volunteers. So we do have a risk management helpline, which comes in handy. And it's actually a free service where insureds can call, the board members can call and ask questions. So can you talk a little bit about that, Rachel?
Certainly. I mean, if there's a decision that the board is wanting to make, and they want to have an attorney's opinion, they can call this number and get 1 hour of free legal advice. I would caution that it is not, the attorney would not be able to speak to coverage, so it's not to call to ask if the policy would cover X, Y, Z. But if you have we're thinking about ending this contract, here's, our dilemma, what do you think? Certainly call the number. It's another just valuable resource to the board. And I'm a proponent of using all the resources that they have available, whether it be the property manager, general counsel, the helpline.
Use everything at their disposal, and it's free, so it's a great service. And I have the number up on the screen right now. Again, if you'd like a copy of the presentation with the number in it, it's 855-548-8656, and I can send you the copy if you send me an email to sbranson@kdins.com. Great. And I just wanted to mention one more hotline, which is a claims hotline, which is basically a resource to report claims, and also if you have any questions about the claims process, anything at all about the claims process, you'll have those questions answered with this hotline, which is 1-800-842-8496. And as I mentioned earlier, I do have a marketing flyer, which has claims examples in all of the categories that we discussed: breach of fiduciary duty, breach of contract, etc. I'm happy to send those to you. And I also have a claims services guide, which helps guide you through the claim process. So I can send that to you as well, which will help you and your customers, if you'd like to hand it out to your customers to help them in the claim process. Now, Rachel, if you're working with claims all the time and seeing different situations, do you have any good advice to give to people today regarding claims?
Well, I think number one is if you're in doubt, if it's a claim, submit it. I mean, the worst thing that can happen is we say it's not a claim, but you protect yourself because it is a claims-made policy. So it's when you become notified about that claim. That could be a letter from a homeowner saying, you violated the CCNRs, you didn't hold the election properly, and I want to see all the board meeting minutes for the past 2 years. It's not in litigation, but it satisfies the definition of claim under the policy. We should get that so that we can start working on it and trying to minimize any kind of litigation from that. Let's see, the other thing is I would please always put the general liability carrier on notice, because there are times when there are allegations that trigger both policies. And what that means for the insured is that the general liability carrier and the D&O carrier would look at their respective policies and sort of determine what their respective obligations are. Sometimes the general liability carrier is the primary carrier and the D&O is the excess carrier. What that means is the excess carrier would pay all of the defense bills. That's good for the insured because under a general liability policy, there's typically not an erosion of their limits of liability from defense costs, as there is on a D&O policy. The other way that it's beneficial for an insured is that there is typically not a retention or deductible under their general liability policy. So it could save them some money, and it could keep their limit of liability under the D&O policy intact.
Mm-hmm.
So
it's a win-win. It's a win-win.
Yeah.
Mm-hmm.
I mean, and it doesn't hurt to submit it and have them say, no, it doesn't trigger coverage. And lastly, I strongly recommend that all boards have a designated board email address, that they not communicate with their personal email addresses. The reason for that is if there is ever litigation, the plaintiff's counsel, opposing side, has the right to ask for discovery, and asking for board communication is pretty typical. And if your board communication is on your personal emails are going to be viewed by strangers. So.
So that could be uncomfortable potentially. No, not at all.
So very embarrassing, uncomfortable.
Absolutely. So when you say discovery, that means it can be used as evidence. Is that discovery?
Yep. Well, the plaintiff's counsel can ask for information and then certainly decide if that information would help as evidence in court. Yes, definitely.
Okay, great. Well, thank you so much. Thank you for this wonderful information. It's been very, very helpful and very educational. And again, I wanted to give my email address out one more time. It's sbranson@kdins.com. So if you'd like a copy of today's presentation, please send me an email. And again, I have 2 flyers I can give you. I can give you a claims flyer, which has claims examples, and then I have a claims services guide as well. And I can also give you the PowerPoint. And I'd like to mention that next month, we're going to be doing a social engineering Q&A webinar. And I just wanted to remind everybody that social engineering is now automatically included on the crime policy. It's automatically included, and we'll be doing a Q&A next month to answer all of your questions about social engineering. Thank you, Rachel. Thank you so much. Thank you for your time.
Thank you, Sherry.
And thank you, everybody.
Thank you.
Thank you. And have a great afternoon. Take care.